Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is James Hunsberger. Today's episode is more or even less certainty in EU merger control, the European Court of Justice judgment in Illumina GRAIL. Today's episode relates to the latest chapter in the saga of the European Commission's investigation into Illumina's acquisition of GRAIL for around $8 billion US. This transaction was first announced in September of 2020 and later was unwound in June of 2024 when GRAIL was spun off as a public independent company. Just as a reminder for our listeners, Illumina is a US company that makes next-generation DNA sequencing systems, which can be used in a variety of applications, including in oncology to run blood tests to detect cancer. GRAIL is also a US company that makes non-invasive blood tests that can be used for multi-cancer early detection and allow doctors to screen for multiple types of cancer in asymptomatic patients at very early stages using DNA sequencing, these tests require a DNA sequencing machine like the ones that Illumina makes. GRAIL, as an interesting historical fact here, was initially founded by Illumina in 2016 before being spun off later that year. Today's episode will focus largely on procedural issues and important procedural rights of the parties and the authority that the Commission has to review transactions. But in terms of substantive theories, the agencies on both sides of the Atlantic focused on similar issues. The U.S. Federal Trade Commission and the European Commission analyzed the transaction under a vertical foreclosure theory, essentially looking at whether Illumina, which the agencies characterize as dominant in next-generation sequencing systems, would have the ability and the incentive to disadvantage GRAIL's competitors in multi-cancer early detection tests by withholding or degrading access to Illumina's systems. Both agencies were very public in their concerns that this, in their view, could lead to reduced competition in this important emerging space of multi-cancer early detection. In the 4 years since the transaction was announced, there have been many fascinating twists and turns on both sides of the Atlantic in the antitrust review process for this deal. Longtime listeners of the podcast may recall that we've done 2 episodes on the investigations by the European Commission and the Federal Trade Commission into this transaction, starting with episode number 141 in November of 2021, and then also episode number 200 in December of 2022. Further detail on the substantive theories of harm and much of the prior procedural history is covered in those episodes and well known to our listeners. So for purposes of today's episode, I'll just summarize a few of the key prior developments. In March of 2021, following a complaint by a third party, the French Competition Authority referred the transaction up to the European Commission under what's known as Article 22 of the EU merger regulation. That request was later joined by competition authorities in Belgium, Greece, Iceland, the Netherlands, and Norway. This referral to the Commission, as we've covered in our prior episodes, was controversial because at the time, GRAIL did not have any sales in Europe or actually anywhere else in the world. As a result, the transaction did not satisfy any of the EU member state turnover thresholds. The Commission accepted that referral from the member states and in July of 2021 opened an in-depth investigation. In August of 2021, while the Commission's in-depth investigation was still ongoing, Illumina closed the acquisition of GRAIL. Later in July of 2022, the General Court, as we'll get into today, the EU's Court of First Instance, sided with the Commission and upheld the Commission's assertion of jurisdiction to review the transaction. In September of 2022, the Commission completed its review and prohibited the transaction based on what it viewed as concerns that the merger would harm innovation and reduce choice in the multi-cancer early detection tests. Then later in July of 2023, the Commission fined Illumina 432 million euros for closing the deal before it had received approval by the European Commission, which it said was in violation of the EU merger control rules. This was the highest ever gun jumping fine imposed by the Commission. Then in October of 2023, the Commission issued an order that would require Illumina to divest GRAIL. Meanwhile, on the other side of the Atlantic, there was extensive parallel proceedings in the US. Long story short, in December of 2023, the Fifth Circuit Court of Appeals upheld key aspects of the decision by the FTC commissioners, finding that the transaction was anti-competitive under United States antitrust law. Then 2 days later, Illumina announced it would divest GRAIL. The bottom line here is that this case has been fascinating from a procedural and substantive perspective. And as we'll explore today, this case raises a critical issue for companies and for deal makers considering deals in an increasingly complex and uncertain merger control environment across the globe. So with that background in hand, I will introduce my co-host. My co-host today is Matthew Hall. Hello, Matthew. Great to be joining you on today's episode. Matthew, who is our guest today?
Thanks, James. It's good to be back. Our guest today is Nicole Kar. Nicole is a partner and global co-chair of the antitrust practice at law firm Paul Weiss, based in London. She specializes in the full range of UK and EU antitrust, competition, and merger control law, including litigation. Hello, Nicole, and welcome to the show.
Thanks very much, Matthew and James, and thanks for asking me to speak today.
Well, thank you, James, for the introduction. By way of a bit of further detail on specifically what we're going to discuss today, James referred to the Article 22 referral procedure in the EU merger regulation. The European Commission had a practice of discouraging referral requests from EU member states that did not have jurisdiction under their own laws. In 2021, the famous guidance came out from the Commission when it changed this approach, and it said that it would, in relevant cases, encourage and accept referrals where the referring member state does not have initial jurisdiction over the case, but where the criteria of Article 22 are met. The concern here was that particularly in certain sectors, of which this was one, the pharma sector, the Commission was worried that transactions that potentially had an impact in the EU had escaped review at both EU and national level. Some of these are the famous killer acquisitions where a small company is acquired in order to remove it as a potential competitor to the buyer. So that's what the cases that we're discussing today were about, this Article 22 guidance, which came out in 2021. The Commission's decision, as James mentioned, to accept the referral was appealed by the parties to the EU General Court, which confirmed the Commission's decision to do that. That was then appealed to the European Court of Justice, which overturned that decision, thereby rendering the 2021 policy change in effect unlawful. So, Nicole, before we look at those appeals at the General Court and the European Court of Justice in more detail, you looked at a number of these cases, I know. What were the main practical issues and concerns for companies and their lawyers that the 2021 policy change gave rise to?
Yes, thanks very much, Matthew. I mean, there were quite a few practical issues as a result of, as you say, the controversial change of policy in 2021. And the main issue really was lack of certainty. I mean, Article 22, the referral up policy of below threshold cases, was said by the Commission to be a targeted tool that would be focused on specific categories of cases and that referrals would be exceptional. But in the event, the Commission itself said it looked at around 60 cases or so, and it did call up in 3 to 4 cases referred up to it by member states who did not have jurisdiction over the primary transaction. And the only real North Star in the guidance that you mentioned that the Commission issued was whether the turnover of at least one of the undertakings concerned doesn't reflect its actual or future competitive potential or other factors were present. And one of those other factors was that the target had raised significant amounts of equity financing. That's true of many startups. And the guidance was clear that referral risk was sector agnostic, even though the genesis of the concern, the gap case that the Commission had identified and changed its policy as a result of, was around below threshold deals not being reviewed by any European agency, particularly in digital life sciences. So where that left us all, I think, as practitioners, was that it was really hard to determine whether you were truly at risk. And secondly, in at-risk cases, it wasn't really possible to engage with the Commission upfront to get clarity, and all 27 member states, if you weren't prepared to concede that this could be an appropriate case to be referred up. So in other words, put yourself into the category. And that's in contrast, I would say, to agencies like the UK CMA, where you can always send, as you know, a briefing paper to start the conversation and make the points about why this doesn't raise competition concerns. I think, secondly, if you were a merger party who really wanted to take no risk at all, then you had to proactively notify every single 27 member state agency about the deal to start the 15-day clock, because there was no clear indication as a result of the Commission's policy and the call-in Illumina, which happened some 5 months after the transaction actually was announced, as to what constituted being made known to a member state. And you couldn't really deal with the risk contractually unless you notified agencies, because post-closing of the deal call-in was possible. The most you could do as a buyer was to have a no impediment to close condition, which US listeners will be familiar with, and US lawyers, and stipulate that referral up was such an impediment to close in that situation. And all of that uncertainty really led, I think, the lawyers representing GRAIL to say that actually what we thought we were dealing with was an ex-ante system of review, which required that you have a concentration that is mandatory, notifiable, reviewed and cleared or dealt with in another way within a strict deadline. And the GRAIL lawyers submitted that the Commission's policy change, and indeed its review of the Illumina GRAIL transaction, represented a Copernican change in the EU merger control system as a result.
As you say, great uncertainty, difficulty in drafting in transaction agreements, and the parties appealed the Commission's claim of jurisdiction under the EU MR. That went to the General Court, which on 13 July 2022 upheld the Commission's decision to accept that referral request, despite the member states making the referral not having jurisdiction under their own merger control regimes. Briefly, Nicole, why did the GC, the General Court, take that view?
Yeah, very briefly, at its heart, Illumina GRAIL and the General Court's approach, but also the ECJ ultimately, its approach, is really a good old-fashioned case about statutory interpretation, which we as English lawyers are very used to. Illumina's first plea, and really the main show in the case, was that the Commission couldn't lawfully initiate an investigation into a below member state threshold deal. And Article 22 itself is silent on whether a below member state threshold referral is lawful. So I would thought at the time, and still think, quite a careful judgment, the General Court undertook a literal, historical, contextual and purposive interpretation of Article 22 and concluded that the Commission was competent to review such transactions, even if the member states who had referred did not have jurisdiction.
As you say, a careful judgment. I think it's definitely a careful judgment. It's a pretty painstaking analysis going through those areas. I think it's important to flag here as well what you mentioned, the literal wording of Article 22(1) UMR. It refers to any concentration. So there was a lot of discussion about that. Any concentration simply means any transaction. So that was a key point of argument also in the ECJ. So let's look at the ECJ, the European Court of Justice. The parties, of course, disagreed with the General Court's view, upholding the Commission. So it went to the European Court of Justice, which handed down its judgment. Just before we get into the more specific points of the ECJ's analysis, Nicole, maybe you could just summarize, the high-level points that the ECJ really seem to be concerned about here, because it really seems to me to revolve around basic principles of EU law.
Absolutely, Matthew. I mean, I think there were really two key legal principles. The first is that the EU merger regulation, or EUMR as we'll call it, is based on the principle of legal certainty. And indeed, in days of yore, the EU was a key proponent of turnover-based thresholds before the OECD and the ICN and other international fora, as turnover thresholds enable ready self-assessment by merger parties. And that makes sense where you're dealing with a mandatory and suspensory regime, as the EU's is, and where the consequences of getting it wrong include fines of up to 10% of global group turnover. And the second key legal principle is more unique to the EU, which is the interinstitutional balance between the Commission and the member states. And the EUMR itself represents a process of compromise and balance of competencies between the Commission and the member states, and explicitly includes a mechanism for departing from the terms of that compromise. Article 1, subsection 4 and 5 of the EUMR enable the Council, on a proposal from the Commission, to revise the thresholds and the criteria defining the scope of the regulation. And the court ultimately found that this review procedure ensures that any changes to the scope of the regulation are made through a formal legislative process, thereby maintaining the balance of powers, so-called principles of subsidiarity, between EU institutions.
As you say, key principles there, and I think it's quite interesting to look at the Advocate General who advises, of course, the European Court of Justice. That opinion came out on 21 March 2024 before the ECJ's judgment, which came out on 3 September 2024. The Advocate General in paragraph 216 makes the comment, in one fell swoop, by means of an original interpretation, which maybe is a bit of a tongue-in-cheek comment there, of Article 22, the Commission gains the power to review almost any concentration occurring anywhere in the world, regardless of turnover and presence in the EU and value, at any moment in time, including well after the completion of the merger. So kind of the definition of uncertainty, if you like, there. So that's the kind of high-level EU law analysis. Nicole, looking at these four areas of interpretation which the GC, the General Court, looked at, how did the European Court of Justice, I mean, it's a very long judgment, of course, so we're not going to go through all of these points, but looking at those four areas, what do you see as the key kind of points that the ECJ relied on and, of course, agreed with the parties about in overturning the Commission's referral decision as upheld by the General Court?
Yeah, so I think there are really four ways in which, as you say, the literal words of Article 22 were considered by the ECJ. And the first, it looked at, obviously, the words on the page, and it said that the courts can resort to other methods of interpretation to clarify its exact scope. We know that very well as English lawyers. And that allows us, and the court was right, to look at historical, contextual, and teleological or purposive interpretations of the provisions. But what the ECJ did was go much, much further back in time and look at a much greater body of the, and I'm sorry, as an Australian, I will absolutely slaughter the pronunciation of travaux préparatoires, or the negotiating or drafting history of Article 22 and consider its legislative history. And the Court of Justice found that Article 22, or the so-called Dutch clause, was originally enacted to fill the gap where member states, like Luxembourg today, but back then the Netherlands, didn't have national merger control regimes in place. So the General Court found that the ECJ found that the General Court had made a mistake in its historical interpretation of Article 22. There was a specific purpose, and the approach the Commission had taken was not seeking to fulfill that purpose. Then it looked at the contextual interpretation of the merger regulation and related instruments. And it also found that a contextual interpretation didn't support the General Court or Commission's broad interpretation of Article 22. And it found the General Court had failed to consider factors that supported a narrow interpretation, like, as I said previously, the existence of a mechanism to revise thresholds found in Article 1.4 and 1.5 of the EUMR. And then finally, the purposive interpretation of Article 22. The Court of Justice found that Article 22, and very unlike what the General Court had found, was not meant to be used as a corrective mechanism or an anti-avoidance mechanism to allow the Commission to review below the threshold mergers that would otherwise escape EU merger review. Rather, the ECJ found that 22 was there to allow the EC to review transactions on behalf of member states that didn't have their own national merger control regime. That was part of the compromise that had been reached as between the member states and the Commission when the merger regulation had been passed. And the ECJ also found that the Commission's broad interpretation was inconsistent with that clear allocation of power and would lead to a lack of legal certainty. And the point you made about the Advocate General's opinion is very well taken there. I think it also raises a question about EU nexus. If you have a below threshold not notifiable anywhere in the EU, how is there any assurance that actually the Commission is reviewing transactions that only affect its citizens? And the final point, as I mentioned previously, was that the Commission, ECJ found that the broad interpretation jeopardised that principle of institutional balance. And it's for the EU legislature to review EUMR thresholds, or for member states to revise their own national thresholds, not for the Commission to propose and put forward a broad interpretation, which was not consonant with the purpose of Article 22.
As you say, the ECJ agreed on the literal analysis. I mean, the words on the page, it does say any concentration, but then you need to look at a lot of the background, etc., where essentially they disagreed with the GC or the General Court on all the points. And it was therefore the judgment of the General Court was overturned, and the 2021 guidance, as we discussed, is effectively therefore no longer a valid document. So, I mean, I think of most interest, probably for our listeners, Nicole, is looking forward. I mean, on the day of the judgment, the commissioner of the time, European Competition Commissioner of the time, came out and said, well, look, we continue to need to review mergers that are not reviewed under any notification thresholds in Europe, i.e. at EU or national level. She expressly referred to killer acquisitions. I also noted that in the mission letter to the potential new competition commissioner, there's an express reference to her needing to look at killer acquisitions as one of her points. And also, interestingly, on the 18th of September 2024, a direct result of this judgment was evident when referral requests in relation to Microsoft's proposed acquisition of certain assets of Inflection was considered by the Commission. They said that they had not accepted a referral request from various member states in relation to that transaction because they no longer could, because it didn't fall subject to any jurisdictional thresholds, and therefore they couldn't accept jurisdiction anymore. So what is going to happen now? Big question, I guess, but what alternative routes are available to the Commission and the member states? Commission clearly wants to continue to look at these type of transactions itself. So what do you see as the routes, and how is this going to play out?
Well, you stole my thunder on Microsoft Inflection. You're quite right. So, and also the guidance, the guidance is still up, but of course the guidance no longer applies, nor does the Q&A that the Commission put out. I mean, I guess your question, Matthew, and it's a very good one, assumes that there's a meaningful gap to fill. It assumes that lots of killer acquisitions are out and about in the community, masquerading below any member states' review possibilities. But actually, the last couple of digital cases, for example, were captured. Facebook Customer and Adobe Figma were captured by member state regimes. So I guess there's a wider discussion and debate for another podcast about whether or not there really is a huge gap or a significant, meaningful gap to fill. It's not something that the EU or national legislatures thought was a significant problem at the time of the last reform of the merger reg in 2004, or the last time the Commission considered whether further reform was necessary and consulted on this. But we'll leave that for another podcast. As you say, there's no doubt the Commission and many of the national competition authorities do believe there's an enforcement gap, as indeed many international agencies believe the Indian and Australian thresholds are to be amended very soon as well, to also allow for acquisition value thresholds and other means of capturing killer acquisitions. There's really four avenues, I think, and we can talk about the relative degrees, the benefits and disbenefits of these. But the first and the obvious avenue is to amend the merger regulation. But the 2021 policy change, as you've described, really reflected the Commission's desire, at least at that time, to avoid trying to change the legislation. That would require the support of the member states and would risk reopening Pandora's box at a time when industrial policy drivers are already putting considerable pressure on the merger regulation. So I think from the Commission's point of view, there has to be a question about how achievable reform is and what would be the price of such reform. I mean, a variant on merger regulation reform is change the EUMR thresholds under Article 1.4 or 1.5, and that's an avenue that the court itself expressly highlighted. The challenges with that approach is that it would require support from the EU legislature and indirectly the Council and support from the member states, and it would obviously take time. That may be time that the EC doesn't feel it can afford. But actually, there is a real and present gap fill in the form of the third possibility, which I think is the most short-term likely possibility, which is that more member states reform their domestic merger regimes to capture transactions like this. And that could take two forms, really. One is that member states could amend their national laws to lower their notification thresholds or include new ones. So Germany and Austria, as you know, included an acquisition value threshold. Portugal and Spain have market share thresholds. Or member states could permit call-in of transactions they felt merited review. And we see that approach in Denmark, Hungary, Italy, Iceland, and others. And that would lead to more transactions falling within the scope of member state review and would enable more referrals under the conventional wording or understanding of Article 22 back up to the Commission. The downside, of course, of this approach is that this would lead to a proliferation of fragmented approaches to merger control, which presents another challenge for the EC, but it may be the lesser of the two evils from the EC's perspective. So the final possibility is that member states rely on the tower cast decision. And I know that's been covered in previous podcasts. But for those listeners who maybe can't recall the detail, in Towercast, the court confirmed that member states could rely on Articles 101 and 102, so our rules against anti-competitive agreements and abuse of dominance, to review acquisitions by dominant undertakings that fell below the EU and national thresholds and so weren't notifiable. But as the Advocate General, Cocotte in that case, said, this mechanism should remain the absolute exception. Despite that, France and Belgium have already taken this route with cases in their jurisdictions. And there are some pretty significant limitations to that route as a gap filler. The first is, of course, this only applies to undertakings that have a dominant position. Secondly, because it only deals with the strengthening of a dominant position, the target presumably has to be in the same market as the acquirer. So that ultimately limits the scope of applicability of Towercast to, for example, Illumina, which was a vertical case and not a horizontal one. And finally, because abuse of dominance powers are subject to strict proportionality and other limitations, it would be quite difficult to use dominance provisions to unwind a concentration that had already been implemented.
Nicole, you referred in your discussion there of those various factors to industrial policy considerations and the current debate and discussion in Europe around the impact that the European competition rules and enforcement might be having on the competitiveness of Europe and European companies in the global economy. Do you have a view on how those discussions and those considerations factored into the ECJ's decision here and how those considerations might factor into the solutions that you just, or potential solutions or potential routes forward that you just discussed going forward?
Well, I think the court took a very conventional legal approach in many ways, taking the four kind of historical, literal, purposive, etc. approaches, contextual approaches to the statute. I don't think they were bearing in mind wider industrial policy considerations or European competitiveness considerations. Many people did make the point, I think, in submissions that are public to the Commission, including, I think, some of the groups of American companies like AmLaw, that this was a real issue in terms of jurisdictional reach, but also concepts of comity with other regulators. As the best placed, we used to have this concept of best placed regulator with the closest nexus to a transaction, reviewing the transaction. Obviously in global markets, everyone feels they have a stake, and that's understood. But I think in terms of where the Commission goes from here, that kind of discussion about competitiveness, particularly in the startup economy and the digital economy, where actually the exit routes for a small startup, which do find it difficult, they typically find it difficult to flourish in Europe more generally because of perhaps a different depth of capital markets and a different approach to the regulatory environment that startups face. Closing off one of those exit routes has definitely been a feature of other cases we've seen. So that was a reasonably large feature of Facebook Giphy, for example, as it was fought in the CAT in the UK. So I do think those kinds of considerations will inform the debate about where we go from here, particularly on EU legislative reform of the merger regulation.
It seems that in all of its comments, including a speech given on 6 September by the Competition Commissioner, that the Commission is considering that the best route at the moment, if you like, best route for it to claim jurisdiction is by member states, quotes, expanding their own jurisdictions, which could include, of course, the call-in rights that you referred to. But as you say, there's lack of legal certainty even in relation to those call-in rights. Do you think the European Court ultimately may have a view about that? A lot of these call-in rights are very wide in scope, a bit unclear. So could we end up in another case at some point looking at that issue?
I do feel one of the casualties of I think the rising difficulty, the concern levels amongst regulators, and I often call it Facebook Instagram remorse. Why did we not look closer? Should we have intervened, etc. I think one of the casualties of that has been legal certainty. And I think there is just this general feeling amongst agencies, sometimes correct, but I'm yet to see kind of empirical evidence that there is this gaping gap in the fabric of our merger rules. I think on call-ins, has been a feature of, for example, as you know, the US system for a considerable period of time. I think if used sparingly and judiciously, countries have found ways of trying to, I suppose, allay investor fears that their deals are going to be upset or unsettled. And many of those mechanisms have involved, if you feel you might be at risk because the deal is going to be viewed as anti-competitive in some way, early engagement with a regulator via a briefing paper, which I understand also happens in Sweden, for example. So there are ways and means, but you're quite right. If the law becomes an excuse to use call-in very, very frequently and indiscriminately, and in cases not raising obvious competition concerns, I do think that has a tendency to undermine investor confidence and certainty and of deal planning, which is ultimately disruptive to economies as a whole.
Thank you, Nicole, for this really fascinating discussion and insightful advice and perspective for companies and for deal makers. This has been a wonderful discussion, so we really appreciate you joining us here today. We like to wrap up, as you know, as a frequent listener of our Curious Amalgam, with a more personal portion of the program. And so we usually start out by asking guests, please tell us something that's interesting or unusual about yourself that we wouldn't know if we only worked with you professionally.
Well, I think I have given this story to a journalist once before, so it's not an entire secret. But I did make a fool of myself as a junior lawyer by sitting in court in front of a judge and snapping a rubber band, which unfortunately flew far from my fingers and hit leading counsel in the face. So that was a particularly memorable moment for me in my early legal career. But I guess, obviously a very closely guarded secret is I'm Australian, but I've been in the UK for quite some time. But I mean, even the cabbie this morning asked me when I arrived from Sydney. So there you go. You can't shake an accent in 23 years.
Well, you seem to have recovered nicely from the rubber band incident, Nicole.
Thank you.
So our next segment is, and one where we finish on is, as you know, called The Curious Hat.
And now it's time for The Curious Hat.
So we will start, if you could provide a number between number 1 and 19, and we'll ask you the corresponding question and go from there.
15, please, James.
15. If you could choose free front row tickets for any performing arts show or sporting event in the world, what would you choose?
Oh, Taylor Swift, every single time. I feel huge remorse that I missed her concert in London. My kids went, but I was not the happy recipient of a ticket. So yeah, absolutely Taylor Swift.
The sacrifices we make for our children, I guess.
Absolutely, yeah, endless.
Well, that's wonderful. Thank you. Thank you again, Nicole, for joining us on this program. And thank you to our guests for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.